Mr. Holmes appeared at 36th District Court intoxicated.
No, the pretrial conference, with this being a 2019 case, I'm going to ask the court to give us an adjournment to try to locate the complainant.
Hold on, sorry. Where's he going? Where's he going? Come back. Hold on.
He's going to the restroom, Your Honor. I was going to take him.
Unless you, it's okay, because it's a bathroom in the back. But you can go ahead and take him to the men's room as long as you are going with him to the men's room.
Yes, Your Honor.
Mr. Holmes is not free to leave.
Yes, Your Honor.
11th at 8:35. Have a great day. Stay safe.
You too. Thank you.
All right, you're welcome. I'm ready on Pettis. This is case number 19450.
Thank you, Your Honor.
Excuse me, Your Honor.
Yes.
Mr. Holmes needs to use the restroom again.
That's too bad. Take him in the back. Take him in the back.
Your Honor, there's a reason why he has to use the restroom so frequently.
I'm
You want-
sure.
yeah.
Probably diluted that urine for that drug screen. I would have to go to the bathroom too if I kept diluting my urine, but it's not going to help him today.
That's correct. He did.
The defense counsel here, objection to all this defense counsel here, just
All
objecting to this testimony.
It's no testimony. We having a discussion about why your client has gone to the bathroom 3 times since he's been sitting in court. I'm not testifying. I'm making an observation. That urine is probably diluted, but he didn't have to drink all that water today because I'm not going to give him a drug test today. Not interested in one. All right. I'm ready on, who did you ask me to do first?
What's your name for the record?
April Danielle Collier.
Today is the date set for review.
She was sentenced on July 30th, 2020.
She's out. Just know I'm ready on Holmes. Okay, I'm ready. I'm ready on Holmes. Let's bring Mr. Holmes to the podium, please. This is case number 20460. Hold on, I'm sorry. 20460. 3301, the people of the state of Michigan versus Daniel Holmes. Defendant is charged with breaking and entering. Today is an adjourned final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And Ryan Murad, PA 3665 on behalf of Mr. Daniel Holmes. Mr. Holmes, state your name for the record.
Daniel Holmes.
Today is the adjourned date for the final pretrial conference. The reason that the final pretrial conference was adjourned was because Mr. Holmes appeared in my courtroom the other day, and I believed 99.9% that Mr. Holmes was intoxicated. Mr. Holmes could barely sit up in his chair. Mr. Holmes' speech was severely slurred. Mr. Holmes was operating in a fashion that caused the court to stop the proceedings. When I stopped the proceedings, I ordered Mr. Holmes to report that day for a urinalysis. I indicated to Mr. Holmes that the only drug test result I was interested in was the one that was going to be completed that day. I specifically said approximately 3, 4, 5 times, who knows, that I wanted Mr. Holmes to go to the to submit to urinalysis that day, that I wanted to see his result. And then I said, if he had a negative result, he didn't have to come to court today. Then after he failed to show up, Ms. O'Driscoll, did you receive any report with respect to Mr. Holmes and the urinalysis?
Yes, good morning, Your Honor. Jennifer O'Driscoll on behalf of the probation department. The defendant failed to report to ATS for drug and alcohol testing on February 4th, 2022. And then he attempted to report this morning, approximately 9 o'clock. However, the sample they were unable to test due to a dilute.
All right. After I received the email from Ms. O'Driscoll indicating that Mr. Holmes had failed to appear, I instructed counsel, not this counsel, I will say misdemeanor and felony defender's office. So I instructed Ms. Stevenson to contact Mr. Holmes, and I instructed my clerk to contact Mr. Holmes and tell Mr. Holmes that he was to immediately appear to the court. Mr. Holmes indicated that he was going to try to get a ride, and then he called back and said he didn't get a ride. And then I checked the news. I checked with I don't know what it's called now. The DOT, whatever they calling it now. I checked to see if they were on strike, if the buses still ran. I was checking to see if I could get a Lyft or Uber. I went on my app, see if I could request a Lyft or Uber, and I was able to request a Lyft and an Uber. So I was completely I didn't have any understanding as to how Mr. Holmes couldn't get down to court. Now, today is Friday. Mr. Holmes has asked to go to the bathroom about 3 or 4 times. Additionally, according to the testing site, Mr. Holmes appeared for testing today, which would have been a complete waste of his money. I don't even know why he would go spend some money on a drug test that I could care less about. I was clear when I said I was only interested in one drug test result, and that was the one that he was going to give to me on the day that he appeared in my courtroom drunk. I am of the opinion that he appeared in my courtroom drunk. I am holding him in contempt of court. His speech today is not slurred. His standing today is not weebly and wobbly. So I am convinced that had he appeared for that drug test, it would have been positive. But since he didn't appear, it's still positive, because a missed test is a positive test. Mr. Murad?
So, Your Honor, the court is correct that Mr. Holmes did not appear to the test that one required to do so. I just want to point out a few things, Judge. One, Mr. Holmes is destitute. He clearly doesn't have a reliable means of transportation. He was ordered to report to drug testing, and I believe, please correct me if I'm wrong, almost immediately. And Your Honor, what my understanding is that at that time it wasn't feasible for Mr. Holmes. I've also checked the Department of Transportation records, and the last bus, Your Honor, that's even close to my client's home, with the last time it leaves is at 12:32 p.m. And Your Honor, I know from the time that the hearing was over, which was already a final pretrial conference, by the time they get heard, are typically closer to 11 a.m. Judge, I'm not offering the court an excuse regarding my client's failure to do it. It is what it is, Your Honor. You ordered him to test. He didn't test. Here we are. But I do want to add, Judge, that although the court was very dissatisfied with his appearance and he was observed slurring, or maybe was observed weebly or wobbly, I'm not sure that Mr. Holmes has ever had Zoom before, and I'm not sure if there's anything else going on with Mr. Holmes. I'm not sure if he has mental health issues. I'm not sure if he has any medical diagnosis. Your Honor, I can't speak to my client's necessity to use the bathroom 3 times today, given that there was an attempted test and the result is allegedly diluted. There's not much I can say there, but I can say, Judge, that it's not out of the norm for somebody Mr. Holmes' age to use the bathroom 3 times before 11:20 a.m. And
I bet you if
without
he
going
was
too
on the
far.
Game of Thrones, what's that thing? I bet you if he was on there, the Game of Thrones, and I bet you if he, when he's at work, he doesn't have to go to the bathroom that often. And
Well,
Mr.
Judge,
Holmes
I mean,
appeared in court before, and he didn't have to go to the bathroom that often. He
Well,
didn't go to
Your
the
Honor, I guess I
bathroom
would
that
argue
day.
that
He
we
was
wouldn't
drunk
know.
on my screen.
And I know that's the court's opinion, Your Honor. And I want the opportunity to rectify this issue. But I think the court is pretty upset regarding the fact that the court did give him an opportunity to rectify the issue, and he didn't. I know the probation department, I know the court, I know everybody works their role and does a great job at it. And had Mr. Holmes just shown up, even if he tested, Your Honor, he was never ordered not to consume alcohol or not
No,
to
he's ordered
indulge
not
in
to come to
controlled
court
substance.
drunk. That's contempt of court.
And I understand that, Your Honor. And I'm gonna make an
Right.
argument, Judge, that the court's not gonna like. I'm gonna
I
argue
know.
that there's really no way to tell that Mr. Holmes was actually drunk. There was no way to tell an odor. There was the
Oh, I've
court's
been living for
impression,
55
which can be
years.
attributed to multiple things,
All
Your
right.
Honor. It
Well,
can be
we're gonna
attributed to multiple.
we're gonna find out. It was a good argument. Mr. Holmes, do you want to say something before I tell you how many days you're getting ready to spend in the Wayne County Jail?
I ain't had no ride because I had to take care of my baby. And my uncle just took me today. I ain't had no ride or nothing. I tried my best to get up here, best I can. I ain't never missed no court day.
You sound good today. You sound good. You look good. Sound great. Mm-hmm.
I know how to take care of my baby. Man, I got 2 kids too. I'm the only parent in the house.
Well, you weren't a parent that day anyway, because you were drunk.
My baby mama had the kid.
Okay. And that's why you felt free to be drunk.
I don't.
Mr. Holmes, I'm gonna advise you not to make any other statements, Judge. I just want to add, I get the severity here. If Mr. Holmes in fact was drunk in court, that's unacceptable. That's a very scary thing. But I do want to also point out, Judge, is Mr. Holmes is still a kid. He was born in 1999. I would ask for the opportunity to get with Mr. Holmes and to work with him throughout this case, Judge.
You're going to get an opportunity, Mr. Mariah. You are, but he's a grown man.
Can I get that without him going to jail, Judge?
He's going to jail. He's going 3 days in the Wayne County Jail, including today, Saturday, and Sunday. They'll release him on Sunday. He's going 3 days in the Wayne County Jail for contempt of court for 2 reasons. One, for appearing in court intoxicated. He was intoxicated. Let me make the record clear. Mr. Holmes was intoxicated. Now, he may not have been drunk, so let me change my language. Mr. Holmes may not have been drunk. He was intoxicated with something, whether it was alcohol or drugs. Mr. Holmes appeared at 36th District Court intoxicated. And when I gave him an opportunity, because he insisted that he was not, I gave him an opportunity to prove me wrong. I'm not relying on Mr. Holmes' uncle to take him any place. I'm not relying on Mr. Holmes' relatives to take him any place. I ordered him to get a drug test, and he failed to get a drug test. He failed and refused to get a drug test. Now, if his uncle wasn't going to take him on the day I said take him, then he shouldn't even ask his uncle. Why waste a favor to go to a drug test today? Mr. Holmes could have walked to that drug facility.
Judge, it would have taken him several hours. I've looked.
Yeah, like the 4 hours that it took
several
the man
hours.
who used to walk to work for 4 hours one way, work, and then walk back home for 4 hours. There's no excuse for Mr. Holmes not to have gotten that drug test. Or what he could have done is simply just admitted, Judge, I'm sorry, and I did come to court drunk. Let me just sober up and come back, right? What I know for sure is that he appeared in my courtroom intoxicated, and I'm holding him in contempt of court, and he's going to jail for 3 days. With respect to the final pretrial conference, the court is going to continue a not guilty plea on his behalf. And I believe that on the day that he was drunk and I refused to hear his case, I believe that on that day, and you can try to confirm this with Ms. Stevenson, we were continuing his not guilty plea. And what did I do with my, we were continuing, or you all wanted to continue his not guilty plea. Mr. Holmes was on the jury trial track, and I was going to give him another final pretrial conference. If that's what you still want to do, I will do that. But he is getting 3 days in the Wayne County Jail for contempt of court. He shall not be released before those 3 days is up. If the jail tries to release you, if I were you, I would just say, Doc, let me stay here, because she's going to put me back here. If I find out that he was released before the 3 days, he is going back. It is contempt of court, and there is no early release. The contempt does not conclude until the 3 days is up. Sir, don't ever appear in my court drunk again. Don't do it. Don't do it.
Your Honor, if I may.
You may.
If defense can produce some evidence that reinforces and corroborates our belief that we believe Mr. Holmes may be slightly cognitively impaired.
He might be
Would the co-
impaired. He was impaired
that-
and drunk. Let me, he was impaired cognitively. If he's cognitively impaired, then on that day, he was cognitively impaired and drunk. Because if he's cognitively impaired, then it should be stopping him from standing up straight. If he was cognitively impaired, then his language should be slurred the same way it was slurred that day.
Well, Judge, I would need the opportunity to examine what medications he takes, what any diagnosis may
You
be,
can,
whether
but
he was
he's
on any
going to jail
medication.
today. He's going
Well,
to jail
Judge,
today.
can we
Mr.
hold that
Murad,
in
I'm
abeyance?
finished with your, no, he's going to jail.
Can
He's
we
going to
request a
jail.
show cause hearing for some sort of proof that my client was actually intoxicated that day, Judge?
Call his uncle or whoever he said he take care of and ask them for his medications.
Your Honor, if I may,
Sure you may.
I've already done the research to see, because I was initially under the impression that he may have mental illness or have cognitive impairment. He does not have any form of mental illness and does not take any form of medications. And I have spoken with him and his multiple family members also. And
Well,
they-
he doesn't have any diagnosed mental illness issues,
Yes.
but he may not have any diagnosed mental
There's no
illness.
doubt, yeah.
But I don't know if he's mentally ill or not. What I'm telling you is if he is mentally ill, if he does have some type of mental health diagnosis that is to be had, it is in addition to him being drunk. It is in addition to him appearing to the court intoxicated. And for that, and for the failure of him to report for the urinalysis. Now, what we can know for sure is that he could get to the urinalysis. It's possible for him to get to the urinalysis because
With sufficient notice, Your Honor.
he went there today. You don't have to have notice. The court, I'm not required. Why would I give you notice so you can clear up your system? Mr.
Judge,
Murad,
if you're
there's
under-
one thing I know for sure. Is that I know how to test for you for alcohol abuse. And it is an immediate testing. And Mr. Holmes was required to immediately appear. That was the court's order. He did not comply with it. He's going to jail and I'm finished. 3 days. Miss
Your
Stevenson.
Honor, with the,
No, Mr. Murad. Hold on, Officer Crafts. Miss Stevenson, were we continuing his not guilty plea? I mean, were we continuing him on the jury trial track?
we are, Judge. Judge, would the court consider a house arrest sanction in lieu of the jail time? If there's any slight reservation that my client may have mental health issues, the last place I think he should be is in the jail. And I think we all have a duty to help preserve that, Your Honor.
I don't have a duty to preserve it. He was drunk. And he came to court drunk. I don't have any
Well, Your
duty
Honor-
except for the duty that I'm having. And if I give him a tether, they're gonna hold him for 5 days trying to give him a tether. So
Not if you allow him to be released, report to the tether unit today before 5 p.m. Get that tether on
I
today.
can't
And
trust him to go to the drug screen. You think?
what if I took him myself, Judge?
You think his uncle gonna take him to get a tether? Come on, somebody.
What if I took him myself, Your Honor?
And then what if you get there yourself and they say we don't have any tethers available because there is a line for tethers? Now he's out
Then-
without a tether. Mr. Holmes is going to the Wayne County Jail. Thank you all so much. I'm ready on cargo.
Judge, would the court hear any additional arguments?
No,
Thank you, Your Honor.
you're welcome.
And Your Honor, that concludes my portion of the docket.
Well, just stay here with us. I'm just messing with you. See you
I'll
this
be there at
afternoon.
1:30, Judge.
See you this afternoon.
Thank you, Judge.